123 artists have filed an amicus brief or friend of the court brief due to their interest in the subject matter. So here is that motion.
This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
So there's a lawsuit against Led Zeppelin. They apparently supported the band Spirit. Spirit wrote a song called Taurus in 1968. Led Zeppelin supported them on their first tour after their song was launched, and that's important because that could be the access that you need for substantial similarity. Meanwhile, Stairway to Heaven was then released in 1971. Spirit was unhappy about not being credited or paid and felt that Led Zeppelin had ripped their music off. In 2014, Led Zeppelin plans to make a remaster series, and Mark Andrés sues Led Zeppelin in Pennsylvania and wants a co-writing credit and appropriate payment for late guitarist Randy California. In 2016, a jury decided that Led Zeppelin did not plagiarize the descending chord sequence heard at the beginning of Stairway to Heaven. They did not plagiarize it from Spirit's 1968 track Taurus. In 2018, the Ninth Circuit Court of Appeals found that the jury at the original trial was not properly instructed and sent it back, I'm guessing, for a second trial. Led Zeppelin then filed for an appeal, asking for a larger group of judges to sit on the case. Request was granted. In September 2019, a panel of 11 judges will sit in San Francisco and consider the appeal. So for that panel of 11 judges, 123 artists have filed an amicus brief or friend of the court brief due to their interest in the subject matter. So here is that motion. We have 123 songwriters of North America moving for leave to file this amicus brief. The friends of the court is what they call the amici. A case like this, particularly one that is brought almost 50 years after an alleged infringement, when it is inconceivable that anyone in the free world is not familiar with Stairway to Heaven, affects many, many more people than the parties in this case. In fact, the panel appeared to have gone out of its way, in its opinion, to make policy decisions that had less to do with this case and much more to do with future cases. This is a decision that, if adopted by this en banc court, truly does impact adversely every songwriter and musician. The panel decision contained 3 significant rulings concerning the propriety of certain jury instructions and 1 ruling concerning the propriety of a playing of an otherwise irrelevant sound recording to the jury in order to assess credibility. If adopted by this court, these rulings would likely stifle the creativity, etc. The panel held first that the district court erred by failing to instruct the jury that the selection and arrangement of unprotectable music elements is protectable. Significantly, during trial, no evidence was presented by plaintiff or his expert that demonstrated that any selection and arrangement at issue in plaintiff's work Taurus consisted of a single compilation of a common musical element that was arranged in an original way. Rather, the purported selection and arrangement that was presented was simply a combination of random unprotectable elements. By making this ruling, the panel necessarily determined, or at least given credence to the argument, that the arrangement and selection that was presented by Skidmore rose to the level of an original work. By so ruling, the panel drastically expanded the basis for finding copyright infringement in music cases. Indeed, the end result of this ruling, if adopted by this en banc court, would be that trivial and commonplace similarities between 2 songs could be considered to constitute the basis for a finding of infringement. Second, the panel ruled that because the jury was not instructed that a selection and arrangement could be protected, it was erroneous to instruct the jury that common musical elements such as descending chromatic scales, arpeggios, or short sequences of 3 notes are not protected by copyright. This ruling was in direct contravention to established copyright law, which provides that such elements, which are the basic building blocks of musical composition, are not protected. Isn't that what they just said? The panel ruled that because the jury was not, it was erroneous to instruct the jury that they are not protected. I guess I see it. The jury was not instructed that it could be protected, so it was erroneous to say that it's not protected. Got it. Third, the panel definitively and correctly held that for music that was created prior to February 15th, 1972, it is only the deposit copy of the work, the specimen, and not the sound recording that constitutes the relevant work at issue in a copyright infringement case. The panel then completely eviscerated the import of its own holding by finding that the otherwise irrelevant sound recording should be played to the defendant, in this case Jimmy Page, in front of the jury for the purpose of evaluating the defendant's credibility concerning his lack of access. Of course, once a jury hears the sound recording for purposes of access, it will necessarily be unable to unhear and disregard the recording for purposes of determining substantial similarity. Such a ruling, if adopted by this court, would cause substantial prejudice to every songwriter defendant who disputes access to a song that falls under the 1909 Act. In addition to causing substantial prejudice, the underlying premise of this ruling is erroneous. Playing the sound recording to the defendant in the jury's presence cannot possibly be probative to the issue of access. The access that is at issue in this case is not the access that the members of Led Zeppelin have to Taurus now. It is their access to Taurus before they wrote Stairway to Heaven. There is simply no relevance whatsoever to the reaction of the members of Led Zeppelin to hearing a sound recording of Taurus, perhaps for the 1000th time, in a courtroom in 2016, to whether or not they had access to the recording 46 years before when they wrote Stairway to Heaven. In sum, the panel's decision improperly extended copyright protection to public domain elements. Such an extension, if adopted by this en banc court, would be certain to result in excessive and ultimately unwarranted copyright litigation in the music community. The decision will also substantially stifle creativity and cause significant confusion among songwriters and future songwriters. Let's see. They're claiming that the appeals court panel previously held that commonplace song elements are now protected by copyright, and that would create significant confusion as well as significant risk of stifling creativity and causing excessive and unwarranted litigation. Let's see. The panel ruled that it was reversible error for the district court not to provide a jury with an instruction stating that the selection and arrangement of unprotectable music elements is protectable. That really says nothing other than that they told the jury something's protectable. What is it? What is the thing that they're saying is unprotectable? It is hardly a novel concept that a selection and arrangement of otherwise unprotectable elements that is original can be subject to copyright protection. However, there was no evidence presented at the Led Zeppelin trial that the otherwise unprotected elements that appeared in Taurus were presented in such an original pattern or compilation as to garner copyright protection. Okay, so they're saying that evidence wasn't presented of it. Instead, the evidence of some selection and arrangement of unprotectable elements merely consisted of random similarities of commonplace elements. Now, I have issues with using the word random when you don't actually mean random. When you mean unpredicted, that's the same as random. Such as the existence of descending chromatic scales and two-pitch sequences in different melodies that were scattered throughout the beginnings of songs. After filtering out the generic elements or musical commonplaces identified in Taurus under the extrinsic test, what remains are two completely different songs. More specifically, both songs start with chords that, according to both sides' experts, are commonplace. In fact, both songs include an arpeggio, which means breaking chords so their constituent pitches are heard separately rather than simultaneously, which again, both sides' experts agree is commonplace. Both experts also agree that these broken chords pitches are played in different order in Taurus than in Stairway to Heaven, which makes the two songs' melodies different. In fact, the two songs' melodies' lowest pitches are a descending chromatic scale, which is nothing more than the white and black keys of a piano played in order right to left. This is not original. Oh, okay, I get that they're saying that you're not inventing the descending chromatic scale when you play the black and white keys next to each other right to left on the piano. However, the standard for substantial similarity isn't, did somebody at one time play the same notes as you? The standard is whether you put some kind of creativity into it, even if you used unprotectable elements, and now you've created some kind of new protectable copyrighted work because you've arranged selection and arrangement. So what they're arguing is that there wasn't any or enough evidence in the Led Zeppelin trial on Taurus's behalf to show that there was some kind of protectable selection and arrangement of unprotectable elements. Even assuming that Skidmore had identified the existence of an original pattern of commonplace musical elements in Taurus that could be the subject of copyright protection, because the work embodies at best the minimum of creativity for any protection, the protection is thin. Moreover, to prove infringement of a selection and arrangement, the copying has to be virtually identical, so they're going to say that it's not virtually identical here. By ruling that the jury should have been instructed that the selection and arrangement of the otherwise unprotectable music elements is protectable under these circumstances, the panel necessarily added copyright protection where none existed before. This is contrary to established copyright law. Okay. Then the second thing was, the panel was correct that the instruction that commonplace music elements such as descending chromatic scales, arpeggios, short sequences are not protected by copyright is correct, and there should not be a reversal. So then they're holding that these short phrases like arpeggios and sequences of 3 notes and things like that should not be copyrightable. And I sort of agree. That's rather established how short sequences of notes work and all that, and it's more the total composition that we're looking at with substantial similarity, not really any one thing. However, if there, like they said, there was sort of a striking similarity or actual copying, that also counts as copyright infringement. Indeed, by their very definition, elements that are in the public domain and scène faire are free for all to use. At a minimum, the panel's decision, if adopted by this court, would cause substantial confusion. Any artist who reads the opinion may very well fear that the very common use of any descending chromatic scale, arpeggio, or short sequence of 3 notes, or elements in the public domain could form the basis of an infringement action. The end result of the panel's rulings on these jury instructions, if adopted by this en banc court, is that full copyright protection will be afforded to musical works, unlike other works, in the Ninth Circuit and no other circuit, based simply on the fact that the works contain the basic building blocks of musical composition, even when they are not arranged in any original way. This is especially problematic because in music, unlike films, books, etc., there is a limited number of notes and chords available to composers, and composers are therefore more restricted in their options. And then they're upset that the jury got to hear a song. I'm going to skip that. It does. It sounds like it could taint the jury if the jury is able to hear something that they're not otherwise supposed to hear in that context. And let's see here. The panel held that the jury should have been present when the sound recording of Taurus was played for Jimmy Page. According to this panel, the jury should be allowed to observe Jimmy Page listening to Taurus, which would have enabled them to evaluate his demeanor while listening to the recordings, as well as answering questions. By holding that the sound recording can be played in front of the jury in order to assess credibility, the panel improperly expanded the scope and breadth of the copyright at issue. In determining whether a defendant is liable for infringement, a jury is not going to be able to ignore or unhear the sound recording that it just heard for purposes of assessing credibility when it is deciding the issue of substantial similarity. There is no doubt that the jury will be consciously or subconsciously comparing the 2 sound recordings to determine substantial similarity, and the defendant will not be allowed to defend himself by presenting expert testimony about the lack of substantial similarity. Accordingly, allowing a plaintiff to play the sound recording to the jury for the purpose of determining credibility is extremely prejudicial to the defendants. And they also did it as a way of attacking his credibility on lack of access, which they said above, the access would have been before the Stairway to Heaven song was written, not after, not now. So that's what they're going to argue here. And they say that there's a bright line test for film, television, and books that does not exist in music cases. In the world of film, television, and books, the universe of choices is unlimited. One can write about past, present, future, etc. Yet, notwithstanding those unlimited options, there is somewhat of a bright line test for infringement in the film, television, book world that doesn't exist in music. With a film, etc., the language is easily understood by the court. The court conducts the extrinsic test by comparing plots, sequences, characters, themes, mood, and pace. The court also filters out scène affaire, such as a car chase or a magician pulling a rabbit out of a hat. A motion for summary judgment in cases will weed out the protectable elements from the unprotectable elements. It will then demonstrate how the works are different and how any perceived similarities are based on commonplace unprotectable elements. The language spoken by the experts is typically one the judge understands. In music, the choices are limited. In fact, there are literally 12 notes per octave, and not all those notes can be used in the same song. Yet, notwithstanding the severe and actual practical limitation of choices in music cases, the line drawing that exists in film, etc., copyright cases, does not appear to exist in music cases. Musicologists speak a language that is often foreign to judges and juries, and therefore confuses judges into denying summary judgment motions whenever two musicologists disagree. The unfortunate result is that summary judgment is very difficult to obtain in cases involving music, and a defendant is often forced to go to trial even when the works do not share any substantial similarities of protectable expression. This is particularly so when a plaintiff can hire 3, 4, or 5 musicologists, conflict out 3 of them that find no similarities between any protectable elements, and know that even if he only has 1 musicologist that can argue a case for infringement, he will avoid summary judgment. It is essential for musicians and composers to be able to find spark anywhere and everywhere without having to constantly look over their shoulders and be worried about being sued. To extinguish this spark and replace it with fear is to stifle creativity and deprive society of the next generation of great artists and new music. And then they've cited the blurred lines decision there. So what do you think of that? That sounds a little complicated, but if we take our time, we can get through it. Basically, the jury heard the music, and they didn't want the jury to hear the music. I don't know the exact circumstances under which the jury heard the music, but it was in the context of attacking someone's credibility on the access to music issue, and I don't see how playing the song helps establish or de-establish credibility on a access issue in a substantial similarity inquiry. What does that have to do with access? Did you have access to the song before you wrote Stairway to Heaven? So playing it for you does what? How does that prove that you had access? You're going to hear it and be what? Shocked? And that's what you're hoping for? I don't think that doesn't sound like it. And then supposedly the Stairway to Heaven arpeggio or sequence that's at issue, they're saying is unprotectable in Taurus and Stairway. And so it shouldn't have been instructed to the jury as being protectable. So we'll see what the judge, or rather the en banc panel, has to say when they rule, hopefully coming up here in September. And we'll do a video on it. Let us know what you think in the comments below. Of course, this is a really heated issue and a hot topic. The Katy Perry song, a lot of people disagreed that the descending minor ostinato in Flame and the one that Katy Perry used were so similar that they could be copyright infringement, and that Katy Perry owed $2.4 million, or rather the collectively the defendants owed $2.4 million. I think Katy Perry's share of that was 500,000 or 600,000 or something. A lot of people disagreed and thought that those two phrases, while they certainly sounded similar and maybe even sounded substantially similar, that the elements were unprotectable because they're very simple scène affaire style elements in music. It would be like trying to copyright the millennial whoop, you know, whoa, whoa, you know, something like that, and saying that nobody could ever put that in your song because you had a whoa, whoa, a whoop, whoop in your song. Yeah, at some point you can certainly copyright your expression of the whoop whoop or whatever, but the basis of is your song copyrightable just because you have a whoop whoop in it and somebody else is infringing if they have any whoop whoop in it. That's not copyright substantial similarity. And then where is the line in between? If they sound exactly the same, but really it's just this sequence of notes. Oh, you know, is that really copyrightable? That's barely creative at all. And let alone here it's music and you have a limited number of notes and limited octaves in which people's voices work. You know, so there are going to be limited expression, a limited number of ways to express the same idea.
Yeah, like if you had whoa, whoa, you'd probably be okay, right? But if you had whoa, 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 well, that's a song.
Right, exactly.
That's
as you start to get longer, it's going to become really obvious at some point that you're copying them, that you're copying someone else. It's almost like you can't even argue against it after you get past the 100th note that's exactly the same, or 1,000th note. So okay, let's just like dial it back. How about at 10 notes? How about at 20 notes? How about at 30 notes? What if it's 10 notes that have the same voice, that have the same tone, you know, with a piano sound or a vocal sound or whatever, that have the same sound to it? Not just the same notes, but the same sound. Is that 10 notes? Is that 5 notes? What if it's not the same sound, it's different sounds, but it's the same notes? Is that 30 notes? Is that 50 notes? There's gonna be some level in here. So let us know where your threshold is. Where do you think Stairway to Heaven infringes on Taurus, or where it doesn't? And what would it have to do to infringe, or what would it have to do to not infringe? If you feel it does infringe, what would it have to do to not infringe? If you feel it doesn't infringe, could it become infringing if it had copied more, and what would that be? Let me know in the comments below. So that is our show. Thank you very much for joining me. I am Leonard French, your favorite copyright attorney. Do we have treats for dogs? Can I get a treat for a dog?
Elsa.
There we go. There's a good boy. There's a good boy. Thank you very much to our patreon.com/LJFrench and sponsors.org/law supporters. Would you like some help with that?
Thank you.
Is that what you're trying to get at? Are you going to call him over? Is that what you're doing?
I'm calling her over. Come on, Pop.
Calling her over. Okay.
Pop.
At the $500 level in the month of August, thank you very much to Joshua Davis from Tanda Pay. We're making a video about his social insurance program. Thank you very much to our $50 plus supporters: John Steele, Gavin Barnard, Evie, Kyle Mudrock, Michael Pierce, Jan Negre, Blackleaf, Spirit Bear, Daniel Perez, Snorri Wazatsky, Not Mike, Joe Tyson, and King Macro. And thank you very much to the $5 plus supporters who are scrolling on the LED panel above me, and you'll all appear in the description of the videos below. I am Leonard French, your favorite copyright attorney. This has been Lawful Masses Wednesday, August 7th. Thank you very much for joining me. I'll see you in the videos that drop. Love you all. Bye.